You know, family court cases can feel like this endless maze, trapping you in a cycle of conflict and, let's be honest, a cycle of cost. Today, we're not just going to break down how that happens, we're going to show you exactly how to build a permanent exit ramp. So let's dive right in.
So let me ask you this, and it's a really important question. Is your court case a one-time thing, or did you accidentally sign up for an unwanted subscription to future conflict? Because that's what it can feel like, right? Complete with those monthly invoices. This explainer is all about helping you cancel that subscription for good.
So what exactly are we talking about here? The source material calls this the litigation layaway trap. Now, this isn't some big shadowy conspiracy. It's more of a system problem. It's what happens when your court orders are built on a really shaky foundation. A foundation that makes future disagreements not just possible, but, well, predictable. It's a loop, right? A vague order leads to conflict. That conflict leads to another court filing, which leads to another bill, and on it goes.
Okay, so how does this trap even get built? It's usually not by accident. According to the source, there are 3 specific levers inside the system that get pulled time and time again to generate repeat business and just keep these cases churning. The first, and honestly the most common lever, is what's called ambiguity farming. This is when your court orders are just filled with these pleasant-sounding but totally unenforceable phrases like, oh, reasonable access, or liberal contact. I mean, they sound great, right? Very collaborative. But what happens when your idea of reasonable is completely different from the other parents? Well, you're right back in front of a judge, paying lawyers to argue over what a word means.
Next up, we've got motion conditioning. This is where the process itself kind of trains you to litigate. So a small disagreement, say about a holiday exchange, it doesn't get solved with a quick text or a phone call. Nope, it instantly gets turned into a formal, expensive motion. The whole case just develops this rhythm where the default response to any friction at all is to file something with the court, which absolutely guarantees constant, low-level legal conflict and, of course, the costs that go with it.
And the third lever is complexity stacking. And this one is surprisingly counterintuitive. You'd think adding experts, like a guardian ad litem or a custody evaluator, would solve problems. But if you do that without super strict rules for their scope, their timeline, and their billing, they can actually create new things to argue about. Before you know it, you're back in court, not just arguing over parenting, but arguing over what the professional's report was supposed to mean.
Okay, so we know how the trap is built. Now let's talk about how to actually spot it. How can you become a trap detector in your own case? You will hear these phrases all the time. Oh, that's just standard language. That should be a massive red flag, because guess what? Your family isn't standard. Don't worry about the details is another huge one. Listen, in court orders, the details are the only thing that keeps you from having future court dates. These phrases are just dangerous shortcuts that almost always lead to a much longer, way more expensive journey.
And it's not just the language. You have to look at the process. Are motions being filed without solid, organized evidence to back them up? That's a huge sign of legal churning. Are your settlement drafts just littered with words like, as agreed? Well, that's just kicking the can down the road for a future fight. And you got to watch out for those temporary orders that just drag on for months or even years. They have a sneaky way of becoming the expensive, permanent reality.
Okay, everybody, listen up. If you take only one single thing away from this entire explainer, please make it this. This is the failure mode test. For every single sentence in your agreement, you have to ask this question. If the document doesn't give you a clear, automatic answer, then the default answer is always, well, I guess we go back to court. This one question exposes pretty much every weakness in a proposed order. It's that powerful.
So knowing the problem is half the battle, right? Now let's build the solution. The source outlines a really powerful 4-part framework for creating court orders that are actually designed to keep you out of court. And here it is. Every single clause in your order needs these 4 ingredients. It's not enough to just state a rule like parents will share costs. You need the process. How is that cost requested? How is it paid? You need a hard deadline. And most critically, you need the failure mode. What happens if someone just refuses? Without all 4, you don't have a solution. What you have is a future argument waiting to happen. Just look at the difference here. On the left, you've got the trap liberal phone contact. I mean, what does that even mean? It's a guarantee you're going to fight about it. Now look at the right. That's the fix. It's specific, it's measurable, and it's enforceable. There is simply no room for argument, and that clarity is exactly what keeps you out of the courtroom. Let's look at a couple more. Reasonable parenting time becomes a detailed calendar, down to the minute.
Joint decision-making, which is a huge source of conflict, becomes a structured process with proposals, responses, and firm deadlines. Even something like no disparagement is totally useless without a clear definition of the behavior and a specific consequence. The pattern here is crystal clear. You have to replace vagueness with process.
So building a bulletproof order is step one. That's huge. But, life happens and disagreements are still going to pop up. The real key is having a pre-built plan to resolve them without immediately running back to court.
This is called the dispute ladder, and you should think of it as your pre-court filter. Instead of filing a motion at the very first sign of trouble, you're required to follow these steps. It forces calm, structured communication first. But here's the brilliant part. If you do end up in court, you walk in with proof, Exhibit A, Exhibit B, Exhibit C, showing that you tried to resolve this reasonably and the other party just refused.
Before you or your attorney even think about filing something, you gotta run it through this checklist. Is it about a real material issue, or is it just an annoyance? Do you have your evidence packet locked and loaded? Did you try the dispute ladder? This simple filter can literally save you thousands of dollars on what the source calls fluff motions that go nowhere and don't actually solve anything.
And hey, if you do need to bring in an expert, you control that process from the very start. The appointment order needs to be incredibly specific. Define their exact scope, set a hard deadline for their work, establish crystal clear rules for communication and billing. This is what prevents the expert's role from spiraling into a second, super expensive case within a case.
And this is the ultimate payoff for using these tools. You completely change the story you present to the judge. It's no longer a messy he said, she said situation. It becomes a clear, simple story. Your Honor, here's the process we agreed to in your order. Here is my evidence of me following that process, and here is the evidence that the other parent refused. That is an incredibly powerful and simple narrative to hand a judge.
So the bottom line is this. You have to shift your mindset. A court order isn't about capturing a vibe of cooperation. It's a technical specification for co-parenting under stress. It needs deadlines, it needs processes, and it needs consequences. Precision is your best friend, and it is your cheapest protection against future conflict. So I'll leave you with that question. Take a hard, honest look at your own agreements. Are they built with precision to actually resolve conflict, or are they just a subscription to repeat it? The good news is, now you have the tools to tell the difference, and to build your own way out.